So good morning everyone, my name is Lalit Soni and you are watching Drishti IAS. In this live session, we will be talking about the Indian Express news articles. We will see what is in news, we will see certain events which are happening around the globe, and these events can be important for you, so keep a tab on that. So let's start with the practice question which was given to you in the previous lecture. Before that, we will see the outline. First, we will be discussing Rahul debut as LOP or leader of opposition. Okay, so we'll be talking about that because recently he has made a remark in the parliament, and at that point of time there was certain, you can say, the opposition party has said that this is not something to you can say talk about a particular community in a particular way. So that has happened in parliament, and because of which there is a, you can say, a discussion in the public discourse as well. Then second is clarification on the new criminal laws. Okay, so you know that the yesterday from the 1st of July we have moved to the new regime of criminal laws, that is Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita and Bharatiya Sakshya Adhiniyam. So considering that, there were certain, you can say, concerns which has been raised by various states as well as some opposition leaders. So here Home Minister Amit Shah has actually given some kind of clarification in the floor of the house. So we will be talking about that as well as then the project Nexus. Recently, with the collaboration of RBI, there are other banks of international banks or from, you can say, the federal banks of different countries. They have come together and they have started this project Nexus. We will see what is that related to. Okay, other than that, from around the world we will be discussing one or two articles, and then for your own read there will be two small articles today. Okay, so let's start with the practice question which was given to you in the previous lecture. Before that, here you can see this is the front page. First, here this is the opposition gets an address. So basically when we are talking about the motion of thanks, okay, so there is this discussion on debates on that particular motion happens, and the government side, they will give you the response. Okay, so in that particular scenario, here Rahul Gandhi has said that hatred in the name of Hinduism to fear to let's work together. Okay, so basically this is what has been said about a particular community over here, and that is why here the government or the ruling party has called it out. Okay, so that is not important for us to discuss. Just know that there is this motion of thanks which we have already talked about. Okay, and this motion of thanks has such effect that if it is not passed in the parliament, government may fall. Okay, so that is there, because if motion of thanks is not passed, that means that government has lost the confidence. Okay, so that is there. After that, coming to second one, that is new criminal laws come into force. Yesterday it happens. Maximum police custody is still 15 days, can be spread over 2 months. Okay, there was this thing which we have discussed yesterday, that the police custody has been extended up to, you can say, 90 days. Okay, so because of which there were concerns related to the personal liberty. So that is what has been made clear by our Home Minister. He has said that this particular, you can say, custody time will be 15 days, but in certain cases, okay, it can be extended up to 90 days. Okay, so that is there. Then on FIRs and hearing of accused, BNSS sanction fly in the face of Supreme Court ruling. When we are talking about the FIR and the, you can say, hearing, when we talk about the arrest, in all these cases, when we talk about FIR specifically, there is this judgment, Lalita Kumari versus State of UP. In that, it was said that if the case is cognizable, then you have to go for registration of the FIR. Okay, that was there. But certain, when we are talking about the BNSS right now, or the, you can say, criminal procedure, so there are certain changes which are seen over here. So we'll be discussing about that as well. Okay, so that is about the today's discussion. Now coming to the practice question: which Indian state is strategically located in northeastern and shares boundary with China, Myanmar and Bhutan? Okay, so basically they are talking about three states here: China, Myanmar and Bhutan. Okay, so if we look at various states over here, these states here, like you can say Nagaland, Manipur, Mizoram, these you can say three states, they does not have any you can say boundary with Bhutan. Okay, there is only Arunachal Pradesh. See here, they have boundary with Bhutan, this is the boundary with China. Okay, and this is boundary with Myanmar. Okay, so basically you can say Arunachal Pradesh is the state which is having boundaries with three nations, that is China, Myanmar and Bhutan. Okay, I hope that is clear. Now moving further, and we'll start with the first article of the day. Here, maximum police custody is still 15 days, can be spread over 2 months. That is what has been said by Shah. Okay, now as the new criminal laws, the Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, Bharatiya Sakshya Adhiniyam, to replace the Indian Penal Code, Criminal Procedure Code, that is CRPC, then the Indian Evidence Act. Okay, so they have been replaced by them respectively. and they have came into effect from the 1st of July. Now here maximum period of police custody under BNSS would remain 15 days with provision to be spread over maximum of 2 months. Okay, so here they are saying that it can be expanded to maximum of 2 months. Now earlier, if an accused was sent to the police remand and he got himself admitted in the hospital for 15 days, there was no interrogation as this remand period would be expiring. Okay, so let's say there was this person who has committed some kind of, or you can say there was this FIR which has been filed against him on 1st of July. Okay, now the judge, the magistrate, has given the remand for 15 days, and on that particular remand police will go for the investigation and they will interrogate the subject. Okay, but the thing is, if we see, and at that particular first day or second day, if he hospitalized himself, okay, saying that he is not well, or for some reason he is hospitalized for like 15 days. Now that remand period was 15 days, and that has been actually surpassed by this hospitalization, because of which there won't be any kind of investigation, because maximum period on the police remand is 15 days. Okay, considering that, here they have come up with this new idea. In BNS there will be remand for maximum 15 days, but it can be taken in parts within the upper limit of 60 days. Okay, so that you can say remand, time of the remand, that is 15 days, that will stay over stay. But the thing is, if he has hospitalized, okay, so in that case these 15 days will be excluded. Okay, so up to a time of 60 days they can get the remand of 15 days anytime. Okay, so that is the new provision. Justice instead of you can say punishment. As I told you earlier, the name was Indian Penal Code, and now that has been Bharatiya Nyaya Sanhita. Okay, so the nomenclature is talking to you about the, you can say, justice and not about the punishment. So that was their speedy trial instead of delays. Okay, so they have fixed a timeline. We'll be talking about that as well. So that is there. Second, moving here, responding to a question on the objection raised by some you can say MPs from Tamil Nadu, they have actually raised this objection that the naming or the nomenclature of these laws is basically in Hindi. Okay, but Article 348 says that that should be in English. Okay, but the thing is, they have said that nomenclature is in English and laws are there. When we are talking about these laws, they are available in all the scheduled languages. Okay, so sorry, they are available in various languages. Okay, all regional languages. Okay, now coming to here, responding to the question on the objection raised by some including MP from Tamil Nadu to the new laws being named in Hindi, Shah has said that law would be available in all regional languages. Now this is the point to remember for us, that it will be available in all regional languages. I want to say one thing, that the entire law will be made available in Tamil and proceedings will be also there in Tamil. Okay, appealing to stakeholders to come forward with any kind of grievances they have. Okay, so basically they are saying that do not do the politics over the subject. If you have any kind of grievances, direct come and talk to us. Okay, so that is what has been said by the government, or you can say Amit Shah on behalf of the government. Okay, now the new laws bring in the modern justice system, incorporating provisions such as zero FIR. When we talk about zero FIR, that means that, let's say there was this crime which has been committed in Rajasthan somewhere. Okay, but they are not able to file an FIR in Rajasthan, so they came to Delhi, and in Delhi some police station, they have gone there and they have filed the FIR. Okay, earlier there was this case that until unless you have the jurisprudence in that particular area or jurisdiction in that particular area, you will not be able to go for the FIR. Okay, but after some time the Supreme Court and other few changes has been made in the criminal justice system, and we have come up with the idea of zero FIR. Now what will happen is that even though the crime has been committed in Rajasthan, a person who came to Delhi and filed an FIR over here, since this is not the jurisdiction, that is why they will not give any serial number to that. That is why that is zero FIR. Okay, so once this FIR is been filed, it will be filed as zero FIR, and then it will be transferred to the respective jurisdiction. Okay, so that is about zero FIR. Now moving further, here you will see online registration of the police complaints, that is there. Summons through the electronic mode such as SMS, and mandatory videography of crime scenes for all heinous crimes. Okay, so that is what something which has been done entirely in a new form. Okay, we are using the digital as well as the science and technology to in our investigation, so that we can be more precise. The new laws have made forensic investigation mandatory in offences punishable by 7 years or more. Okay, if offence is punishable more than 7 years, or 7 years or more than 7 years, in that case there will be a forensic investigation. So that is there. which will help us speed up the justice and take the conviction rate up to 90%. Okay, so that is there. Then second is 99% of the police stations across the country has been computerized, so that is also there. Digitization has happened. Proceedings of the generating e-record is already started in 2019. You know that earlier there was all the files which are handwritten. Since 2019 there was this instruction that all the proceedings and the work in the police stations will be digitized. Okay, so that is there. Also set of deadline for the completion of all the procedure. Full implementation of the law and will end the endless wait for justice. So basically now they have provided a timeline within which you have to finish the investigation, within which you have to file the charge sheet, etc. We will be discussing it in the next article. The judgment in the criminal case has to be delivered within 45 days of the completion of trial. Just whenever the trial ends, okay, within 45 days you have to pronounce the judgment. Okay, now judgment will be pronounced by the judges, so they can reserve the judgment, but the thing is within 45 days you have to announce this particular judgment. Okay, then charges must be framed within 60 days of the first hearing. So that is also something they have fixed a timeline. Now justice centric approach by the providing community services for the minor crimes. Okay, for earlier we did not have this community service system. Okay, but this time they have actually gone for this community service related punishments. They are saying that for the smaller crimes you are not supposed to send them jail. Okay, first thing, there are social stigma which are attached with the jail. Second thing is our jails are already overcrowded. Now sending everyone for the small issues to the jail, that will not be right. Okay, so that is there. I hope that is clear. Now for the mob lynching, for the first time they have actually gone for the mob lynching related. Now earlier when there was this British time, we had this laws related to mob lynching, but that was not the intent behind those laws. Okay, the intent behind those laws were to serve the British interest, but after that we did not have mob lynching related laws. Now they have actually come for the first time. Mob lynching has been defined with punishment for 7 years of imprisonment to life imprisonment and even death penalty in case something heinous is happening. Okay, so that is about certain things which are there with respect to the custody, with respect to the different kind of justice which we are trying to deliver, that is related to your use of science and technology, use of zero FIRs, digitization, etc., etc. Other than that, the community service related provision and the mob lynching related provisions which are new. Okay, now coming to the next one, that is basically on FIR and hearing of the accused, BNS section fly in the face of the Supreme Court ruling. As I told you, there was this ruling, that is Lalita Kumari versus state of Uttar Pradesh. Okay, so that was a landmark judgment when we are talking about the FIR filing, etc. Okay, so in that particular judgment it was said that it is mandatory to file FIR in the cognizable offences. Okay, now coming over here, a 14 days timeline for the police to register FIR in cognizable cases, the right of accused to be heard even before the case is made out against him. At least 2 key changes in the procedural law in Bharatiya Nagrik Sanhita. Now 2 key changes means that first is the right of accused to be heard even before the case is made out. Okay, so that is one thing. Second thing is a 14 days timeline which has been given to file an FIR. Okay, earlier what used to happen is that if there is a case which you are not able to identify that whether it is a cognizable case or non-cognizable case, okay, in that case the investigating officer can go for a prior investigation, okay, or preliminary investigation that was supposed to identify the nature of the crime prima facie. Okay, not to go for the full-fledged investigation, just to identify whether this case is cognizable or non-cognizable. Okay, if you don't know what is cognizable and non-cognizable, please go and read about it. There are certain terms like cognizable, non-cognizable, compoundable, non-compoundable, bailable, non-bailable. These are terms from the law and judiciary, but the thing is these are as important as for the other aspirants as well. Okay, so you can go and read about these 6 things. If I tell you all of them today, you won't be able to understand, so go and make a table out of it. Okay, this is easily available on the internet. Now first is that 14 days timeline for the police to register FIR. At that point of time you can go for the preliminary you can say investigation. Okay, not investigation, preliminary inquiry. Okay, so that is there. Second is the right of the accused to be heard even before a case is made against him. Earlier when this was happening, or you can say when the judge is taking the cognizance, at that point of time he was not supposed to go for the investigation, or you can say asking certain questions to the particular accused. Okay, because you know that accused is not supposed to say anything in front of this particular thing which is there, that anything you say in front of you can say judge will be used against you. So that is the thing, that is why it was not there earlier, this provision was not there, but right now they have said that the right of the accused to be heard even before case is made out against him. At the time when judge is deciding or taking cognizance, judge is deciding whether to register a case or not, at that point of time if he is hearing to the accused, that cannot be good for the sorry, that cannot be the good for the accused at that point at this particular stage. Okay, so these two changes has been made in the Bharatiya Nagarik Suraksha Sanhita. The BNSS under the section 173 clause 3 states that the cognizable offences where punishment is more than 3 years but less than 7 years, more than 3 and less than 7 years. Okay, a police officer is allowed 14 days to conduct a preliminary inquiry before registering an FIR and then proceed with the investigation in the case. Okay, so basically here they are saying that in all cases it can be done. Okay, but earlier when we are talking about the judges etc., or before this particular section came 173 clause 3, before that it was there that in certain cases only where you are not able to identify the nature of the crime, that is cognizable or non-cognizable, in that particular situation you are supposed to go for the preliminary inquiry. Okay, so there are 2-3 you can say areas wherein you can go for the preliminary inquiry, otherwise you have to register the FIR. Okay, but now they have said that now police officer for 14 days he can take time and go for the preliminary inquiry and go for the you can say filing of FIR if he deems necessary. Now police, considering the nature and the gravity of the offence, proceed to the conduct of preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter within the period of 14 days. Okay, prima facie means that on the face of it, okay, at the look of the you can say the inquiry you realize that this crime has happened. Okay, second thing is proceed with the investigation when there exists a prima facie case. Okay, so first you will go for this preliminary inquiry. In the inquiry, if you see that there has been a crime which has been committed prima facie, then you will go for the investigation. Okay, now inquiry and investigation are two different things. Okay, in the inquiry you will just realize that what is the nature of the case, if there was this crime if at all committed, then if crime is committed then you will go for the investigation of that particular crime. Okay, now this particular provision goes against the landmark 2013 case by the Supreme Court, that is Lalita Kumari versus Uttar Pradesh, that is mandatory for the police to register an FIR. Okay, so in this particular it was said that it is mandatory for the police to register an FIR. Registration of FIR without delay is direction reiterated by the Supreme Court in various cases. Okay, so what they are saying that there should not be any kind of delay, you will have to register the FIR. Okay, now while the Lalita Kumari judgment mandates that the FIR must be registered if the information discloses a cognizable offence. Okay, so they are saying that if there is a cognizable offence with the information you got, you realize that it is a cognizable offence, you have to register the FIR. Okay, that is one thing. When you don't know whether the event which has happened or the crime which has happened that is cognizable or non-cognizable, then you can go for the preliminary inquiry. Okay, now here here allows preliminary inquiry only to determine whether cognizable offence is revealed or not. Okay, just to know the nature of that event. Okay, now under BNSS preliminary inquiry are conducted to ascertain if there is a prima facie case for offence punishable with 3 years or more than but less than 7 years of imprisonment, unlike Lalita Kumari guidelines which specifically categorize the like matrimonial disputed and the commercial offences and the medical negligences, this etc. Actually were earlier there, that in these cases you can go for the preliminary inquiry, but right now BNSS is saying that this can be done for everything. BNSS applies broadly to all relevant offences within the defined punishment range. Okay, so if there is a punishment from 3 years to 7 years, in that particular range they can go for the preliminary inquiry. Okay, now because of which that first there will be a delay in the you can say registration of the FIR. Okay, so obviously it will take more time. So that is there. Now coming to the next part, which is on the right of the accused to be heard, the BNSS make a key change in the provision. Section 200 of CRPC prescribed the procedure relating to examination of a complainant by the magistrate while taking cognizance. Okay, so here you will see there is a complaint and magistrate is taking the cognizance. Okay, so that was the section 200 of the CRPC prescribes the procedure relating to the examination. So that was earlier the case. Now magistrate take cognizance can do so after examining the complaint on the oath once cognizance is taken, the accused is then formally summoned. Okay, so that is what the procedure was in section 200 of the CRPC, that when judge is taking the cognizance, then he will be taking an oath, and on the basis of that oath he will recognize that whether this particular cognizance should be taken or not. Okay, now BNSS in the section 223, cognizance here in simple words means that acknowledgement that it has happened. Okay, so that is what judges are supposed to do when they will go for the, you can say, under oath. They will be asking certain questions, and on the basis of that judge will decide whether this particular thing has happened or not. Okay, so that is what basically is cognizance taking. Now BNSS section 223 retains the provisions but add curious proviso or exception, provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity to be being heard. Okay, so basically what they are saying, that earlier there was no such you can say necessary provision with respect to the, you can say, accused putting forward their own cases. Okay, so here they are saying that accused has to be, or you can say, given opportunity to speak. Okay, so that is there. Now means that the magistrate cannot even take the cognizance of the offence without hearing the accused. Okay, so basically now if you are hearing the accused, at that point of time accused can reveal certain evidences. Okay, now accused has revealed certain evidences. Now there are high chances there will be a biased opinion in front of the, when we are talking about the investigation officer, otherwise also. So that is there. Now 2004 decision of State of Odisha versus Debendranath Padhi has said that the accused does not have right to produce document to prove their innocence during the framing of the charges. Okay, so at the time of framing of the charges or the cognizance is being taken, at that point of time accused are not supposed to put forward any kind of document which says that they are innocent. Okay, so the judge can only consider material produced by the prosecution to avoid roving and fishing inquiry and mini trial at the framing of the charges. Okay, so basically this is what they are saying, that when there is this cognizance taking is happening and the charges are to be framed, at that point of time accused is not supposed to tell you the evidences saying that he has not done it, or which is proving their innocence, because at the time of framing charges, if you are going for the, you can say, hearing the accused, there are chances that you will have a prejudice, or the investigation officer or who is framing the charges, they might have a bias. Okay, so that is why it was earlier not included in that, but now they have said that it should be that accused should be heard before the taking cognizance. Okay, the judge cannot take cognizance unless the accused public servants, in the cases of public servant. Okay, so basically what they are saying, that in the cases of public servant also they are given opportunity to make assertions as to the situation that led to the incident so alleged. This and his superior officer submits a report containing the facts and circumstances of the incidents. Okay, so if the case is against the public servant, that means that he will also be given opportunity to speak. Second thing is, a report will be given by the seniors, that person's seniors, to the, you can say, court. Okay, so that is about this. Here specifically speaking, there are 2-3 things which is important for you, that is 14 days timeline for the registration of FIR, and then if the offence is having a punishment 3 to 7 years, in that cases police can go for the preliminary inquiry. Okay, earlier that was not the case. Earlier there was certain areas wherein matrimonial disputes, commercial disputes, and otherwise also there are 2-3 important points wherein you can go for the inquiry just to determine the nature of the, you can say, crime. Okay, so that is about it. Now we can move further to the next article. Okay, now Rahul Gandhi, Om Birla face off has happened, and who controls Lok Sabha's mic? Okay, Rahul Gandhi was speaking and he has this again and again he has accused the chair that his mic is being switched off. Okay, so the speaker Om Birla, he has said that the job of the speaker, no doubt the mic starts and goes off on the, you can say, direction of the speaker, but the thing is he is not having some kind of button over there to do it himself. Okay, so that is there. We will see who is the person, or the who actually you can say control this mics, etc. Second thing is, this mic, if you are switching it off again and again, does it has anything to do with the privilege of the member? Okay, you know that there are certain privileges which has been provided as a convention. Okay, and they are not coded anywhere, but there are certain convention on the basis of which privileges are given to certain members. And now if you are switching off the mic while he is speaking, so does that have any kind of breach of privileges or not? Okay, now when we are talking about these privileges, these are mentioned in article 105 with respect to your parliament, and then when we talk about article 194, this is with respect to your state legislatures. Okay, so this is where the, you can say, concept of privileges has been introduced. But again, I'm telling you, these are not coded anywhere, they are not written anywhere, these are just conventions which has been followed. Okay, now here you will see the Rahul Gandhi claimed that his microphone has been repeatedly switched off in the house. Okay, casting aspersion on the chair. Okay, or they are you can say that he has actually tried to question the reputation of the chair. Okay, the chair only gives ruling and directions or directives. The member whose name is getting called off in the house to speak, the mic is controlled as per the direction of the chair. The person sitting in the chair does not have a remote control or a switch off for the microphones. Okay, so basically this is what has been said by Birla, that the chair no doubt gives the direction that now this particular member of parliament or this member of Lok Sabha will speak. Okay, then there is a control room from where they will start the particular microphone. Okay, so when we are talking about you can say member who wants to speak, there are certain buttons which are given. There is a gray button on the table, then here they have to press it with raising their hand that they want to speak. Now if speaker allows them, so that gray button, there is a LED surrounding that button, that LED will go red. Okay, and there will be a LED on the microphone as well. Okay, so that will also go red, and that is the you can say indication that now the member has been allowed to speak. Okay, now there is no such switch with the speaker or in the hand of the speaker that he can switch off the mic anywhere any time he wants. Okay, so that was the case over here. Now Rahul Gandhi raised issue last week as well. He has claimed that his microphone has been switched off when he is trying to raising an irregularities, or you can say raising issues of the NEET controversy, etc., which has happened. Okay, now who administered the mics in the Lok Sabha? In 2014 manual from the Lok Sabha Secretariat, each MP is provided with a microphone with a switch at their desk in the house. The system is linked to a divisional seat number allotted to the member. Okay, all the desks are having this way. The thing is, there is a mic on every table and there is a switch on every table, and now all these switches are basically having every seat has a number, and these switches are accordingly settled in the control room. Okay, each switchboard contains switch of different lights. A gray switch can be pressed at a request to the speaker. When the member wants to speak, they raise their hand to indicate the same to the speaker while pressing the gray button. The mic is activated from the control room only when the member is being permitted by the speaker to speak. Obviously, if speaker allows it, then only their mic will start. Okay, now indicated in two ways, with the LED ring around the gray button which is there, which will start emitting red light, and then when we talk about the LED on the top of the microphone also getting red. Okay, so that is the procedure, that is not important for us. Just know that this is the issue which has happened. Now, does turning off the mic constitute a breach of privilege? Now this is important factor for us. In July 2033, leader of opposition in Rajya Sabha and the Congress National President Mallikarjun Kharge, okay, Kharge, and said that his mic was turned off while he was speaking in the house. Okay, he described it as a breach of my privilege, the concept of parliamentary privileges. Okay, so basically freedom of speech and expression, and that is also kind of a privilege which has been given to the parliamentarians. Now the power and privileges and immunities in the either house of parliament and of the members and committees are laid down in article 105 and article 194. Okay, so you can remember that while the constitution has accorded special privileges and the powers to the parliamentarians and legislatures to maintain dignity and the authority in the house, they are not codified. Okay, so that is what I have told you, that these particular privileges and you can say there are some immunities which has been given by constitution. This concept is there in article 105 and 194, but the thing is these are not codified anywhere. Okay, so they have, constitution has said that there are certain privileges which are to be given to the parliamentarians. Okay, but the thing is they have not actually codified it, that these privileges will be there. That is just a convention which has been followed since the time of, you can say, when we are talking about, we have followed mostly the system which is there in the British era. So basically that is why we have some conventions on which we are following. Thus, there are no clear and notified rules to decide what constitute a breach of privilege and punishment it attracts. It is a breach of privilege and the contempt of the house to make speeches or to print or publish libel reflecting on the character or the proceedings of the house. It is committed its committees and its members. Okay, so basically they are saying that without the permission of parliament or without the permission of chair, if you are going for the, you can say, print or publication of the material, okay, that is also a breach of privilege. Okay, so you can go through your article 105, article 194 and related questions. Okay, so that is there, that is all about this particular article. Now moving further, Cheetah stock dwindling in Kuno, plan to move out excess cheetahs. Okay, so basically you know that when we are talking about Kuno, there was cheetahs which has been introduced in Kuno. When we talk about Kuno, Kuno has a population of leopard as well. Okay, and now when we talk about this cheetah, okay, these cheetah are basically the prey base for both of them. Okay, now the thing is, cheetahs are limited, some 23 cheetahs are there. Okay, and but leopards are also there. Now there are theories that the population of this cheetah is declining very fast, and there can be 2-3 reasons. One is either poaching is happening. Okay, second is basically competition between the two species which are there. Okay, and third is basically, you can say that the some kind of other things which might be happening over there, which we are not aware of. Okay, but the thing is, when we talk about poaching, the forest officers over there, they are saying that poaching might not be happening because there are a lot of boots on the ground, and second thing is there are a lot of cameras. Okay, so if poaching like activity was happening, then there can be a, you can say, we would be alert about it. Okay, so that is one thing. Second thing is competition. As I told you, these cheetahs are introduced from Africa to India. Second thing is that there is a local leopard population. Okay, now the population is too much when we talk about these 23 cheetahs, and the decline in the population was such a way that when we talk about these cheetahs, so they go for hunting, like you can say a particular number of cheetahs will be hunted in a particular time. If we go for the numbers, okay, that does not make sense, because the number of the way the population of cheetah has declined, that is way more than the amount that is consumed by the cheetahs. Okay, so that is there. So when we talk about this leopard, okay, leopard are also having a prey base, that is cheetah. Now, but the thing is, there is a particular, you can say, retired officer which is saying that there are high chances that it has something else to, something else is the reason behind that, because when we talk about the drop in the population, so no doubt there is not only cheetah which is there in the prey base, there are other species as well. So why is that the population of cheetahs is only, the population of cheetah is declining? Why is that other prey bases are not getting affected? Okay, so these are certain things which is happening in the Kuno. Now when we are talking about these Kuno, since we are saying that there are number of cheetahs has increased recently, and there are nearly 23 cheetahs. Okay, and it is generally believed that you can say, sorry, there are nearly 26 cheetahs including the cubs. Okay, and it is said that Kuno has a capacity to, you can say, inhabited nearly 21 cheetahs. Okay, so whatever excess cheetahs are there, they are planning to shift them to Gandhi Sagar. Okay, Gandhi Sagar is, you can say, the another or alternative home for cheetahs. We are also hoping that we will be bringing more cheetahs from Africa. Okay, so that is there. So there are 2-3 things which can be important. One is related to your reasons why cheetah population is declining. That can be poaching, that can be the competition between the species. Okay, second thing is, when we are talking about the alternative home, Kuno is there. That was the first site which was considered as the home for the cheetah, which have been imported from the Africa. Second thing is, the thing is, when we are talking about the second alternative place, that is Gandhi Sagar Wildlife Sanctuary. Okay, so that is also in MP. So that is why these two places becomes important for you. Now third thing over here is that what will you do now? Okay, so there are certain things which can be done, that there a big cat or the like lion or tiger, they can be sent to this particular area, because leopard or the population of leopard can be controlled by the population of the big cats. Okay, so if we are talking about since the number of leopard has been increasing in this particular area, so introducing a lion or a tiger, that can be a best deal to control the population of leopards. Okay, so I hope that is clear. More than that is not needed for you. So if you want, you can go through this particular you can say article. Otherwise we have discussed almost everything. Okay, now when we are talking about the location, here you can see this is Gandhi Sagar Wildlife Sanctuary. Okay, this is in the, you can say, northwest of your Madhya Pradesh, and here when we are talking about the Kuno Palpur, that is over here, and it is in the northern part of Madhya Pradesh. Okay, and these two are, you can say, nearly in the vicinity, and there are certain areas over here which is having Rajasthan's land. So basically there has been this corridor etc. in the past few years. When we are talking about, there are certain tigers which has been which has came to, you can say, this particular area of Kuno. It is assumed that there is one tiger which is there, and which has been which has came from the Ranthambore. Ranthambore you must have heard. Okay, so that is in Rajasthan. So that is also area which is habitable for the lions, tigers. Okay, so that is there. Now moving further, there are other important places there. That is, one is Panna Tiger Reserve. Now when we are talking about the Panna Tiger Reserve, you must be remembering the Ken Betwa river water link, a water linking project is there. So that is there. Other than that, here this is Pench. Pench is quite important because half of the Pench is in Madhya Pradesh, and some of that is present in the Maharashtra as well. So that is also important. Kanha is important. Okay, Satpura is important. Durgavati Wildlife Sanctuary status has been changed, so that is also important. Okay, so that is about the protected areas of Madhya Pradesh. Now what is Project Nexus? Okay, now here you will see the RBI has signed off for a project that is named is Project Nexus. The RBI, Reserve Bank of India, has joined Project Nexus, a multilateral international initiative to enable instant cross-border retail payments by interlinking domestic fast payment systems and India's UPI and FPS of Malaysia, Philippines, Singapore, Thailand, etc. So these are the countries which has actually participated in this particular initiative, that is Malaysia, Philippines, Singapore, Thailand and India. Okay, so these are the 5 countries which has joined this initiative, and in future you will see that Indonesia might also join it. Now what they are doing is basically like UPI, okay, unified I don't remember the you can say this full form, but this, yeah, unified payment interface. Okay, so unified payment interface of India, and there are certain, you can say, fast payment systems. Okay, so when we are talking about the fast payment system like UPI, there are other nations which are having such certain systems. So basically UPI plus such fast payment systems of various countries, these 4 countries, they have come together so that they can go for the retail payments at a very fast pace. Okay, so UPI takes seconds. Within seconds there will be a transfer of money. Similarly, they are trying to make it, and you can say for different countries they are coming together and making such things, and under which what will happen is that if someone is making a payment from, let's say, Malaysia, it will be as like UPI, and you don't have to wait for long for that. Okay, so that is there. Now what is Project Nexus? Conceptualized by the innovation hub of the Banks for International Settlements, that is BIS. Okay, Bank for International Settlement, that is BIS. So it is conceptualized by that particular you can say body. It seeks to enhance cross-border payment by connecting multiple domestic instant payment systems, that is IPS, or you can say fast payment systems, in the first BIS innovation hub project in the payment area to move towards the live implementations. Okay, so that is the first such project, you can say. Now Reserve Bank of India has been collaborating bilaterally with the various countries to link India's fast payment system, that is UPI, with their respective FPS for the cross-border person to person or person to merchant transfers. Okay, so person to person transfer is very easy, like a person, I and my friend, which we are going for the transfer of money. Okay, and if I am doing it with a merchant or a trader or a business, etc., in that case that will be person to merchant. Okay, so that is there. Further impetus has been given to RBI's effort in expanding the international reach of the Indian payment system. Okay, so basically you know that we have been giving this technology to various countries, and since we are going for the expansion of in the various other countries, then it means that our system will be there with them as well. Okay, so basically we are trying to give an impetus, or you can say boost, to our own payment system as well. Now in over 70 countries today, domestic payments reach their destination in second at zero cost to the sender or the receiver. Okay, now connecting these IPS to each other can enable cross-border payment from sender to you can say recipient within 60 seconds. Okay, just like UPI, this will be that. What are the benefits of the platform? Obviously, in various countries, first your trade will be you can say benefited. Second thing is payment, there will be no delay in the payment. Okay. Third thing is we are trying to interconnect our economies. Fourth thing is that we are trying to boost our own UPI system. So all these things are there. Other than that, here you can say it is designed to standardize the way of way IPC connects each other rather than a payment system operator. When we are talking about the such payment, and if you are not having such system wherein 5-6 countries are coming together, so then you have to go for the each country individually. Okay. So then it will be use or duplication of the resources, and that is why now we are going for the single one. Okay. So here you can see that it connect, the operators can make one connection to the Nexus platform. This single connection allows fast payment system to reach all the countries on the network. Nexus could significantly accelerate the growth of instant cross-border payments. Okay. So basically we are creating a system, and whenever there will be a transaction, that transaction will reflect in your system. Okay. Now, which country has joined the platform? Malaysia, Philippines, Singapore, Thailand and India, they have already joined it, and in the future there will be other countries which will also be joining. Okay. Now here you will see this particular you can say on June 30th 2024 was the time, then when we are talking about this particular initiative. Then here you can say this was done in the Basel. Okay. Basel in Switzerland. Indonesia will also joining the platform soon. Okay. So I hope that is clear. Now we can move to the next part. Here 2-3 things you can remember, that is the name of the countries. There are 5 countries. Okay. Philippines, Malaysia, Thailand and Singapore and India. Okay. In the future Indonesia will also join. The project is to interlink the payment systems so that there can be a immediate payment transfers. Okay. So that is there. And other than that, if we talk about the you can say agreement on this, the agreement has been signed on the 30th June 2024 in Basel, Switzerland. Okay. So now we can move further to the next article, that is related to the China deploys aircraft carrier of Philippines amid clashes in the South China Sea. Okay. This is not the first time, we have talked about this particular thing for various times. There are areas, when we are talking about this particular area of South China Sea, there are various concerns in that area, where there are various countries which are competing with each other for the exclusive economic zones. Okay. There are islands like Spratly Islands, then we have Paracel Island, Scarborough Shoal, Second Thomas Shoal. All these are the area which has been disputed, and recently China has gone for deployment of an aircraft carrier in that particular area. Okay. And that is why there is this insecurity which has been increasing in the countries like Philippines, etc. Okay. So that is there. We have discussed about this, we have discussed about this map, so we won't be repeating that. Now for your own read, there are 2 articles. One is related to army facing unique operational challenges, say General Dwivedi. So you can go and read about this article. And then moving to the next one, a fishing expedition, Lankan Navy officer's death and 10 Indians who awaits their fate. Okay. So basically there was this fishing expedition which was happening in the international waters when we are talking about the Indian Ocean, and at that point of time they have found these fishermen, and the Sri Lankan you can say personals, they were basically chasing them, and in that particular you can say chase, there was this death of a Sri Lankan you can say Navy person, and ultimately these 10 fishermen has been arrested by you can say their authorities, and now their fate is basically what will happen, that we have to see. So there will be diplomatic channels which will be open for this, so you can go through this article as well. Okay. Now last part, that is basically your question. Gandhi Sagar Wildlife Sanctuary is located in which state? Rajasthan, Gujarat, Madhya Pradesh and Maharashtra. So you can attempt this question and answer in the comment box. So with that, I would like to take your leave, and if you have not subscribed the channel, please subscribe it. Have a nice day. Thank you.